Before I get into it, let me introduce myself. My name is John Wood, partner at the law firm of Green, Klein, Wood, and Jones, the Dragon Slayers. We sue insurance companies. I'm not going to talk about the litigation process. We've had a lot of really superlative first-party attorneys speaking over the last few days, so I'm not going to go back over those things. I'm going to focus on a different form of policyholder advocacy, and that is through lobbying for legislation. Because at the end of the day, we can, as attorneys and as adjusters, you can only get for your clients benefits that they're entitled to under the law. And every legislative session, the insurance companies try to change that law. They try to put new limitations in their policy forms. They try to reform the torts that are available to aggrieved consumers. And so if you really step back, you've got to be in the halls of Congress and in the legislature in order to really perfect the preservation of policyholder rights. So my firm, we've set a couple records for bad faith insurance claims. We do that. We're seeking to be part of the first generation of board certified insurance lawyers in the state. I just published an article in the Insurance Law Journal of Texas on an issue of new form of coverage. And so we do continuing professional education. So we're advocating for policyholders outside of the courtroom as well. Excuse me. And let me just say this. I'm not the only person that thinks what you do is important. In fact, the Secretary of the Treasury of the United States during the COVID pandemic issued a memorandum that made it clear that processing insurance claims is critical infrastructure in the United States. In fact, continuing to keep the claims flowing, to continue processing those claims is a matter of national security. And all of us that are working in insurance claims were deemed essential services. So keep that in mind. What you do is important. And whatever we can do to help move insurance claims forward efficiently, when you aggregate all that work that's being done, it is essential for the United States national security. So a little bit of civics. The Texas legislature, just an overview, they convene every odd-numbered year, January through May. We're a limited government state, and they mean that. We meet every other year, okay? The regular session is only 140 days. The first 60 days, the legislature may only act on items deemed an emergency by the governor in his State of the State address. And this year, the emergency items were cutting property taxes, ending the COVID restrictions, school choice, school safety, securing the border, finding the fentanyl crisis. So there's a lot of things that need to be done. The Texas Senate, there's only 31 members. Right now, there's 19 Republicans and 12 Democrats. 18 votes are needed to bring a bill to the floor. Only a majority of 16 votes are needed to actually pass a bill. And the presiding officer of the Senate is the lieutenant governor. The lieutenant governor is a statewide election, and it is considered the most powerful position in the Texas government. Did you know that? More important than the actual governor. And that's, post-Civil War, the Texas Constitution was rewritten to limit and to spread the power out, to diffuse the governor's power, making Texas a relatively weak governor state. The strongest governor powers are the power of the veto and the ability to call a special session and to set its agenda. So really, it's been the lieutenant governor that is one of the major characters in this story that I'm about to tell you. So the Texas House of Representatives, there's 150 members, 86 Republicans and 64 Democrats this time. And a majority of 76 is needed to pass a bill off the House floor. However, most bills do not advance out of committee. Right? There's a number of different subject matter committees. There is a House Insurance Committee, and most bills that are proposed don't make it out of committee. They're considered, and they simply don't vote them out, and so they never leave the committee. If they do get voted out, they go to what's called the House Calendars Committee, which is responsible for setting the agenda for the House floor votes. And a lot of bills, excuse me, a lot of bills die in the House Calendars Committee. They get passed out of their subject matter committee, they go to calendars, and then they never get scheduled for a floor vote, so they just don't become law. And the reason why the Calendars Committee is so treacherous is because any single member of the Calendars Committee can flag a bill and keep it off of the House floor. And if enough members flag a bill, it'll never get scheduled for a debate, much less a vote. Now the House, the Speaker of the House is Dade Phelan. He's elected by his or her fellow members of the House. Dade Phelan from Beaumont, Texas, is serving his second term as a Speaker. He was selected 147-3, so it was overwhelming favorite to be the Speaker. Now, I'm a part of a nonprofit organization called the American Adjuster Association. It's sort of like just a band of brothers. There's some policyholder lawyers, some PAs. If any of you are interested in being a part of this, by all means, we had some great favor in getting some bills passed in Louisiana. We've just introduced legislation in a number of different jurisdictions, and we turned our sights to Texas because as goes Texas, so goes the nation. And we put forward a couple of policy objectives. One is to help make appraisal more rational, and the other was to have the public adjuster's fees paid just like attorneys' fees are paid under certain circumstances. So to begin our lobbying efforts, it actually starts with what's called an interim charge. So in the period between the regular legislative sessions is known as the interim period, and there are standing committees of both chambers that are commissioned by their respective presiding officers to study relevant issues within their jurisdictions. And this is typically viewed as a prelude of subject matter that these committees will work on and legislate on during the next session. So they're studying, being briefed by their staffers, taking feedback from stakeholders before they go into session. So potential interim charges are sent to the presiding officers from each of the committee's chairpersons, and the presiding officer then makes their determination. And so what we started there is during the interim, we began early. And so I'm telling you this because one, fascinating, it's relevant to your work, what happened this session, and two, you might want to pass laws. And I hope you learn from our experience, and maybe we can convene and strengthen numbers. But this is what happened this session with AAA. We worked with both relevant committee chairmen, the House Insurance and the Senate Business and Commerce committees to socialize our policy proposals for their consideration. And so with the House Insurance Committee, I think that we were quite successful in advocating for our objectives. We put forward a draft charge document. We gave it to the Speaker of the House, and the House, Dade Phelan, actually published our interim charge document. It was sent to the House Insurance Committee, charged by the Speaker to, quote, study the existing state laws, administrative regulations, and agency practices to identify barriers to competition in the insurance marketplace, examine business practices in the industry to determine if additional laws or regulations are needed to promote competition, lower premiums, protect consumers. This led the House Insurance Committee to hold a hearing with the following agenda items, quote, review consumer rights and appraisal in automotive and homeowner policies, review trade industry practices and interactions with insurers and consumers. And this set the stage for 2023 session on appraisal. Now, in the Senate side, there's a Business and Commerce Committee. That would be our relevant subject matter jurisdiction there. And it was a little bit disappointing there because all of the business and commerce charges dealt with business issues only. There were no charges given to the committee to study insurance, property, casualty, auto, nothing. So the Senate was simply not asked to look at insurance during the interim. Nonetheless, we did work that. We did try to lay track there at any rate. Moving forward in the process is bill drafting and selecting your author. And this is a major tactical decision that can really make or break the fate of your law, of your bill, is who is your author. And now there's sort of this general, maybe it's a stereotype, maybe it's accurate, but on the left of politics are the consumer advocates. On the right of politics are the corporate defense attorneys, and that's generally how things go. But Texas is its own political universe, and here we found a Republican lawmaker to be our bill sponsor, our bill author. So we leveraged relationships with our lobbyists, members of both the Texas House and Senate. We found we have our two marquee policy ideas, and we had them drafted for bill filing. And so in Texas, all bills must be drafted by the Texas Legislative Council. So that's another little step in the process, is that we had our internal version of the laws that we wanted to become law, and we proposed them, and then the Texas Legislative Council took them and worked our substantive law into language that was consistent with and referenced and sort of internally consistent with the rest of the insurance code. And so the TLC drafts it in such a way that if they voted it into law, it would seamlessly tie in with the existing legal environment. So we did get our bills back from the Texas Legislative Council. They were acceptable to us. They didn't actually change the merits of the laws at all. It just contemplates how it affects related statutes, and it gets an official tracking number for use in the legislative process. So if you want to look these up, they're actually HB 597 and HB 601. So we secured an author in Representative J.C. Jetton, a Republican. He agreed to carry both the efficient appraisal bill and the PA fee balancing bill. We also had a Democrat Senator Judith Zaffirini in the Senate to carry the companion bills, because as you know, you have to pass the law in both houses and then go to governor's signature. Okay, so 2023 comes around. We've done all this foundational work to get taken seriously once we go into session, and we're going to sort of take these in turn. On the efficient appraisal, we had got the Speaker of the House to tell the House Insurance Committee, think about this. Let's try and make it a better appraisal in Texas. There were 3 different bills filed that dealt with appraisal reform. There were ours, HB 597, and you can look this up. I've got copies of them if you want. I can send you our framework for appraisal. And then there was another appraisal bill that dealt with auto only, and then there was a appraisal bill that basically copied ours, which was flattering, of course, and it was by a member of the House Insurance Committee, and she was basically saying, I want to do this too. Her son had an appraisal that dragged on so long he had to sell his house, so she was saying, I want to be a part of this conversation as well. But as we went forward, none of those 3 bills were getting hearings, and the session was dragging on, and it was starting to get us concerned. We worked really hard on the House Insurance Chairman and the committee staff, and ultimately we did get a hearing for HB 597 set. And there was an organized opposition to these bills from the insurance lobby, as you could expect. We did make some concessions, some compromises. Specifically our proposal was in an appraisal, and I'm going to sort of simplify here, but in an appraisal, you've got the standard, if you and we disagree as to the amount of the loss, each shall select an appraisal, you've got 20 days, and that's about it. There's no further policies, procedures, rules of evidence, timelines, there's nothing else. It's basically the Wild West. And now if you've got honest, in appraisers with integrity, you can get good results out of appraisal. As a trial attorney, I generally don't like appraisal. It's sort of, there's no rules of evidence, there's no rules of procedure, there's no timelines, there's no judicial oversight generally. And if you get a good appraisal award, the insurance company is just going to deny your claim for coverage or causation. If you get a bad appraisal award, you're stuck with it. So I generally don't like appraisal, but at any rate, what we did with this proposal is to put time fences around the appraisal panel. You have so many days to issue your appraisal award, and that way it functions like a liquidated damages clause, and that it actually gets you an appraisal outcome. And we also had a provision there that if the appraisal award was larger than the undisputed settlement offer to date, then the insurance company had to pay the appraisal costs, because the insured should have never had to go through that process to get a proper payment on their appraisal. But in the back and forth with the carrier lobby, we ended up giving up the fee shifting part of it just to get the timelines. And we thought that would still be a great contribution to the industry, that when you invoke appraisal, there's a definite end date after which you will get an appraisal award rendered. Ultimately, all three of those appraisal bills, including ours, were voted out of the committee. And we had highly negotiated this language. Then there is a senator in the B&C committee made a surprise move where he named himself the sponsor of the bill and stripped it down of all of its elements except for one, which says the auto and home policy has to include an appraisal provision. Nobody asked for that. This is how politics works, okay? The whole House Insurance Committee had hashed this out on the merits. We had the concessions. It was a negotiated compromise. The bill that we put forward was sort of the coalescence of those three different appraisal bills. That was what the House of Representatives, representing the people of Texas, and the various stakeholders put forward. And then a senator said, no, let's make this pointless. And so that's what happened. Almost all policies already have an appraisal clause. That isn't really the point. That's not what we're advocating for. At any rate, there was a sense that the bill will be brought up again next session, and that we did break through. We broke a bunch of ice there. We set the agenda. There's now precedent that the House Insurance Committee would approve language that we had put forward. It did get voted out. So there was some progress, if you can count those as wins, short of actually passing a law. And I want to encourage you, I think we do need to count as wins any of these thresholds that you pass, because law tends to be a buckle between power and wealth. And even when you're, like my firm, working on large losses, we're still the little guys, right? It could be a $20 million claim, and you're still the little guy. You're fighting against a multi-billion-dollar multinational corporation that's one of the biggest lobbying powers in the world. So the fact that we were able to get a bill out of the House Insurance Committee felt like a little bit of a win there. At any rate, going into next session, there's some outstanding questions. Are the powers that be going to concur with the changes to this appraisal bill? Are they going to attempt to renegotiate some of those provisions? Could we restore some of the provisions that we had asked for? And so there's a chance there. So HB 4194 is the efficient appraisal bill. It's out of the Senate committee. It's waiting the bill to be called up by the Lieutenant Governor, who, as I said, presides over the Senate. And our lobbyist has been working with the Senate chairman, the chairman of the Business and Commerce Committee office and the Lieutenant Governor's office to get this done. And there appears to be no issue. They can't raise any subject matter specific or merit-based issue with the bill. So when you're getting a bunch of mealy-mouthed talk out, no one can really explain why it isn't moving forward. There is just something going on behind the scenes, some cloak and dagger stuff happening that may explain why they're not bringing this up. Because the Senate Business and Commerce Committee is a powerful chair, and it's that person's bill, and the Lieutenant Governor is squelching this. So it's just interesting to see how politics works. So that's what happened with the appraisal bill. Moving on to the PA fee balancing bill, which I think this is my proudest moment as a lobbyist or as an advocate for policyholders. My dad is a public adjuster. I respect the profession. It's an honorable profession. And one thing that you may have heard a notorious defense attorney, he's based in Texas. His firm represents about half of the carriers in the state, and he's gone on and on about the unauthorized practice of public adjusting and is, in his terms, using it as a cudgel to hit contractors and say, that's unauthorized practice of law. That's a felony in Texas. You're not a PA. You can't negotiate and affect the settlement of a claim. That's a crime. Well, jiu-jitsu, you use the momentum of your opponent against them. Well, let's take that argument seriously. The practice of public adjusting is a carve-out of the practice of law. The PA statute 4102 specifically references the UPL provisions, and it licenses you to be, in my terms, an attorney in fact. Not an attorney at law, but an attorney in fact within the four corners of the insurance policy. You're the agent, the fiduciary of the policyholder, and what you're doing is precisely what an attorney would be doing, short of filing the lawsuit and actually making an appearance in court. And if you follow that logic, in Texas, very conservative Texas, we're not a bastion of consumer protection here. Nonetheless, the wisdom of our legislature has made it legally required that a breaching party pay for the attorney's fees for the non-breaching party in a contract dispute. And our insurance code also requires the payment of attorney's fees when there's a violation of a variety of different provisions of their insurance code. And so it seemed to me that the same logic would apply, that if an insured is required to hire a PA because the insurance company has made an underpayment or otherwise violated the insurance code, that the PA fee ought to be paid as well. And so we put forward HB 601, which would be an amendment to Section 542, and it's essentially restating Section 542 of the insurance code and then adding a new provision. So any of the following acts by an insurer constitutes unfair claim settlement practices. The new subsection 6, compelling a policyholder to retain a public insurance adjuster to recover an amount due under a policy by offering substantially less than the amount ultimately recovered in a settlement with the policyholder. And notwithstanding, an insurer shall pay a commission of a license holder for services provided to an insured as a result of the insurer violating Chapter 541 or Section 542. The payment required by this subsection is in addition to any other payment required under the law. So that was our PA fee balancing, which is to say, if a policyholder is being forced to hire a licensed representative because the carrier is not making an undisputed offer, they're not buying the roof after meeting with the roofer and hearing about the roofer's observations, then the insurance company ought to pay the PA commission as well. And this would be a win-win. The roofers would say, hey, I don't have to take the PA fee out of my repair budget. That's great. The policyholder doesn't have to go to fund my deductible or some financing or take it out of their savings account to pay the fee. And as an attorney, that's another 10% I get to tack onto the damages model. I get to go after a larger sum. And that seemed eminently fair to me. And of course, there was some organized opposition from the insurance lobby to this. But when we had our hearings, the Office of Public Insurance Counsel spoke favorably. They can't take a position for or against the bill, but they spoke favorably on the merits. The Independent Insurance Agents of Texas also spoke favorably about both of our bills. And the PA fee balancing, HB 601, was voted out of the House Insurance Committee, despite insurance lobby opposition. We also beat the insurance lobby in the Calendars Committee, and we got our bill set for a floor debate on the second to last day possible. And indeed, the timing was a concern for us. We were running out of time. And if, we've got a limited window, this limited government here, to get things done. Now, towards the end of the House to hear bills, the minority party typically engages in a practice known as chubbing, which is offering amendments and prolonging debate on bills to kill the remaining floor calendar. So those kind of tactics were also a potential threat. Nonetheless, HB 601 was scheduled for a floor vote, and it passed in a second reading with a vote of 114 to 21, and its final reading the next day, 117 to 18. The Texas House of Representatives voted 117 to 18 in favor of requiring the insurance companies to pay the PA commission when it's incurred as a consequence of a violation of the insurance code. And I think that's a pretty significant victory. We didn't get the law passed, but we got it passed by the House. So the Texas House of Representatives believes in your profession. It believes it's fair to require the insurance company to pay your fee. And in fact, the implication, the corollary, is that it is unfair for the policyholder to be forced to pay those fees. The insurance company ought to pay them. So we were able to get the support of the major caucuses, and that was a big deal for us, and hopefully we can move forward here. Currently, HB 601 is sitting on the Lieutenant Governor's office, awaiting referral to a Senate committee. But it's sitting there along with hundreds of other House bills. Late in the section, a lot of jockeying between the Senate and the House started taking place, and this has become a very bruising, demoralizing legislative session. It's actually taken a very dark turn in Texas political history. And our bill is just one of the many hostages that were taken up, as essentially the Senate is now fighting the House. And one of the ways they do that is by simply not referring the bills. So we have an overwhelming majority in the House passed HB 601, and then it just sat there because the lieutenant governor doesn't want it to advance. And like I said, there's a number of other bills that are in the same fate. Property tax bills, school choice, social issues, a lot of other things that are just languishing because of this fight between the Senate and the House of Representatives. The chatter around the Capitol and on social media is that there's a lot of hostage taking going on. Our HB 601 is one of those hostages, but frankly, there's no reason a bill that earned almost 120 yes votes in the House has not been referred yet. So we are still pushing on the Senate Parliamentarian's Office. They are the gatekeepers of referrals. Yet I think that the issue here is the lieutenant governor. And for whatever cloak and dagger politics are going on, the Senate is punishing the House. And a ton of bills that should become the law of Texas are not going to even be voted on by the Texas Senate. Now, I think... there's a lot of things that we can take away from that, and I'll get to that in a second when I wrap up. But it's just a fascinating situation. You might have seen this. The House Republican leadership, Dade Phelan, was presiding over the House and was visibly intoxicated. He was slurring his words. He was mispronouncing reps' names, and Ken Paxton called for him to resign and said, "This is a disgrace. You've lost our confidence as the Speaker of the House. You should resign." Well, apparently Dade Phelan has better political standing than Ken Paxton does, because Dade moved to impeach Attorney General Ken Paxton. And, the guy's under investigation by the FBI. There's securities issues. I'm not going to comment on the merits of any of those ongoing investigations, but apparently the House had enough. Calling on the Speaker of the House to resign was probably the last straw, and Dade Phelan and the 5-member House General Investigating Committee had already voted unanimously to send 20 articles of impeachment to the full chamber, where they need a simple majority to impeach Paxton. And that might happen. Ken Paxton would be just the third Texan in the history of our republic to suffer this fate. And this is what happens when push comes to shove. So it's an interesting insight into the various balance of powers. Who's more powerful, the AG or the Speaker? Well, the Speaker. At any rate, you could take from this that this was disappointing, that we had two bills, that we did everything right. We started playing the long game way before session started. We got the Speaker of the House to announce interim charge documents that directed the relevant committees to focus on the issues that we wanted to pass laws on. We got the Texas Legislative Council to draft versions of our bills that reflected our intentions. They didn't get bastardized in that process. They didn't get watered down. We had conversations with the Texas Trial Lawyers Association, with the Independent Insurance Agents of Texas. We built a big multi-stakeholder coalition. We got these bills voted out of the House Insurance Committee, and the bill that I thought was the most ambitious, the PA fee balancing bill, which frankly, that takes a big bite out of the carrier's profit margins. I thought that's a pretty big deal, and that passed overwhelmingly by the House of Representatives. But when it happened, I just felt something in my spirit saying, don't spike the football yet, man. This is not over yet. There's still the Senate and the governor's signature, and that was right, that ultimately the breakdown in the democratic process cost us a chance to make that the law of Texas. But there's always next session, and I think that this was a pretty strong show of support, and hopefully we can carry this and continue on and make that the law of Texas. Now, it's not like the Senate voted no. They didn't even look at it. So as it stands, the House of Representatives overwhelmingly supports the proposition that your fees ought to be paid by the carrier. And I encourage the first-party lawyers here, when the facts support it, right? Not when the PA makes the first notice of loss, but when the PA is brought into the file because the carrier's shenanigans. And the facts support it, argue that the PA fee is consequential damages, because that was the logic behind our bill. And the idea that the breaching party ought to pay for the probable and natural foreseeable consequences of their breach goes all the way back to the Roman Empire. Okay, this has been Hadley versus Baxendale, first day of contract law in law school. You talk about this. And in the standard jury charge, I think any corporate representative would have to concede that it's foreseeable if they don't pay the claim properly, the insured's going to have to incur professional costs from the PA. And the standard jury charge would support that, that we should be able to recover that in litigation. And you can also point to this overwhelming support from the Texas House that ought to be the case. Now, we didn't get these bills passed. We made some progress, built some coalitions, I think shifted the Overton window on these issues. But I don't want to call this a failure because of those things. But also, the most important, in my opinion, is that we were playing offense. The best defense is a good offense. They can't score on us if they're playing defense, right? And we set the agenda. We came in with a vision. We were the ones briefing the lawmakers on these issues. We were the ones drafting the bills. And we controlled the narrative. Okay, we were at the hearings. We controlled the narrative. And the biggest evidence, in my opinion, that this was a successful legislative session is Steve Badger complaining on LinkedIn about how no one was consulting with him or his clients on these issues. That's exactly what I was hoping to do. We can get through another legislative session without him controlling the narrative on insurance issues, without the insurance lobby driving the boat. I mean, every other year, we've got to deal with another attempt to take a bite out of the apple by the carriers. Let's limit the policyholders' rights to recover. Let's limit what the roofers can do. Let's do all this stuff to make it harder for the policyholders. Well, not this time. This time, at least, nothing bad happened. All right, and I call that a win. We didn't lose any more ground. We didn't get another blue tarp bill. We didn't go the way of Florida, which took away bad faith and attorney's fees. So I count that as a success, and I think that we need to stick together. We have plenty of controversy on our side. We have to raise our standards. Conferences like this do it. You keep the standards high. Knowledge is power, especially in the claims environment. But we also have to take our advocacy into the halls of power. We have to take them into Austin, and this is a model for that. And I hope that you're inspired by it, and that we can continue to coalesce and organize and have strength in numbers as we do it. And that's all I got for you. Thank you.